Hello and welcome to Legally Speaking with me, Tarun Nangia. The Supreme Court Collegium, headed by Chief Justice of India, Justice Deepak Mishra, resolved that transfer of judges as and when decided will be put up on the Supreme Court website. We see that the past 2 years has seen a lot of debate on judiciary, appointment of judges, now transfer of judges, and judges themselves have been forthcoming and speaking on the issue via the media or otherwise. In these times of debate and discussion, and what should evolve of the Indian judiciary and how should we move ahead? I have with me today Justice Jaspal Singh. He is former judge of Delhi High Court. I have got with me Member of Parliament, eminent jurist and senior lawyer, Advocate Abhishek Manu Singhvi, and I also have Advocate Suman Jyoti Khaitan. He is founder of Khaitan and Company and a very well-known corporate lawyer. Welcome all of you for sparing time and joining me on this issue of Legally Speaking. So, as we'll start this show with opening comments from all three panelists on this decision of the Supreme Court to put up the transfers on the website. Justice Jaspal Singh, so after this decision, when you read this news, what would be the first thought that crosses your mind?
Well, I do agree that it's a welcome step, but it doesn't mean much in substance. You have transferred and then you have put it on the website. It will be within hours. It will be on media.
Yes.
So I don't think of course, Supreme Court cannot give reasons.
Yes.
Should not give reasons. There can be very many reasons which may be not good to be disclosed. And this phenomena of transfer is not new.
Yes.
In 90s, I remember in Delhi High Court, 3-4 judges were transferred. During the regime of Chief Justice Venkatachalaya.
Yes.
And then there were 2 of us who were to be elevated.
Yes.
And they said, no, we will not elevate them in Delhi High Court. And they were sent to Rajasthan High Court.
Yes.
So transfers is not a new phenomenon.
Yes.
There can be very many reasons for transfer. But then those reasons, I think, should be, sometimes it may be very embarrassing to disclose them. But if they can be disclosed,
yes,
they should be disclosed for the health of the system. But supposing, just now I'll give you an example. 3 of the judges from Delhi High Court were transferred.
Yes.
And within a short span, they have been transferred back.
Yes.
Now it's very intriguing. What was the reason to transfer them? And what is the reason that they are being sent back? They are good judges. I don't say that. There must have been some reason. But has that reason evaporated? Or what happened? The public should know. It can be very dangerous.
Justice Jaspal Singh has made a very pertinent and important point, and we'll go ahead and discuss this. Opening comments from Mr. Singhvi.
There are 2 aspects I wanted to address on your transfer issue. One is that we must make a distinction between the Chief Justice and the transfer of a judge. Now, let's step back for a minute. You know, we have a condition that the terms of conditions of service of a judge cannot be altered to his detriment after his appointment. That's a fundamental bedrock of judicial independence. If I appoint you and then I start tinkering with your terms of service, it is an adversity. And the reality is that a transfer is a monumental harassment to a judge because his entire life gets uprooted. So first point is that a judge has to be transferred only for very strong, clear reasons. Because you like it or not, you say on all these judgments, these nice words you use, but in effect, virtually every transfer is punitive.
Yes.
Unless somebody wants to be transferred out of Sikkim to Delhi, the reverse. In most cases, it is punitive, whether you use the word or not. So that is the Chief Justice is on a different footing because in most cases, and I think that part has worked well actually, that's why I'm making a distinction, he is being promoted.
Yes.
I am a judge of court X, he is the sitting Chief Justice of this court, I am number 1J. From my state, I am about to be elevated as Chief Justice elsewhere. That in 90% cases is not a punitive transfer. Yes. So we must make that distinction, point 1. 2, there is no doubt that at all times, but in particular in the recent past, and I'm going to be blunt here, I'm going to take names which she has not taken. Transfers which are mindless, transfers which are wrong, which are arbitrary, and cannot be described anything other than punitive. Now, you can't be punished for the way you write judgments. Tell me a single good reason why a man like Justice Shakdar can be transferred.
Yes.
Tell me a reason, and I don't know the man at all. I've only argued before him once. Chief Justice Joseph of Uttarakhand is an outstanding judge. I argued a matter for almost 6-7 days, the Uttarakhand matter. There is not a single lawyer in the bar who will say this is not outstanding, not good. The man seeks a transfer to Hyderabad, not to his own state, because his health in the hills is a little difficult.
Yes.
Why is he kept pending for the last 1 year for a transfer?
Yes.
According to me, he is Supreme Court material. Take the example of Justice Jayant Patel. Apart from many other issues there, you are transferring to Allahabad High Court as J5, J6.
Yes.
And he's J2 in a state with 1 year left to go. These punitive things have to be stopped. You can't give lectures on judicial independence and allow this to happen. And again, you can criticize the government, and I have no doubt the government plays a bad role sometimes, all governments do. But ultimately the power lies in you. You are the collegium.
Power lies in the collegium.
So no excuses, reiterate it, and then punish the government if they don't obey your...
Mr. Singhvi is actually as frank as he can get and as candid on this topic. I have Advocate Khaitan with me. Sir, your opening comments.
See, transfer in India, for most posts, I look at it as something punitive or political motivated, etc. Even in judiciary, it's no exception except for the Chief Justice, which my friend pointed out. If you see historically, by 50s, 60s, 70s, there was no talk of transfer. Now, one reason why transfer was talked about is that lawyers, you tend to be, it's a family kind of a profession. So when you're practicing in one court and you get appointed in that court, you have friends, you have colleagues, you have relatives practicing in that court. So that was one criticism, that some people are known to you, some people are not less known to you. So those judges should be transferred. That may be a valid reason. But I would go a step further and say the reasons for each transfer should be made public and should be made or placed on the website. I'll tell you why. India is a democracy, it's a republican. We are a republic, the power vests with the people. Why should the people be denied a right to know what is happening merely because it is embarrassing? Then it's all the more reason. Supreme Court had held in case of executive long before the RTI Act came in 75 that in this modern world there can be but few state secrets. If something involves crime detection or international relations apart, every transfer, according to me, and every reason, you must give a reason. Why? Because accountability is with the people of India.
I take your point, and taking this debate ahead, I'll ask Justice Jaspal Singh, sir, and this is specifically to you. Do you feel overall that adequate weightage is given to the opinion of the relevant Chief Justice under whose High Court this transfer is effected? Or is it so that the Supreme Court takes a call and the Chief Justice is not heard, or enough weightage is given to his opinion, and what impact can it have if it is not done so?
Well, I do not know whether Chief Justice is consulted at all.
Yes.
And in any case, Chief Justice has nothing to do with it. You ask the judge concerned as to whether he is willing or not, and this is the reason. I still remember one of the judges who was transferred, he wrote a letter to the Chief Justice of India.
Yes. That
please tell me the reason why I am being transferred.
Yes.
And there was no response at all. At least courtesy should have been shown to him. Then look here, we have received your letter.
Yes.
But then why not respond? He is the only, I think, solitary case of Delhi High Court where the judge concerned wrote a letter and asked for explanation.
Sir, I'll take your statement ahead, and you have Justice Chemaleshwar.
I am naming him. He was Justice S.N. Agarwal.
So Justice Chemaleshwar has opined that it should be made mandatory for the Collegium to record its reasons for selecting a person for appointment as judge of the Supreme Court or the High Court, or transferring a judge from one High Court to the other. So I will like to get in Mr. Singhvi on the discussion. Mr. Singhvi, once you read what Justice Chemaleshwar has appointed, do you see that the Supreme Court is also getting serious of what it should do in future with regards to transfer of judges?
Well, first of all, the new transparency rule, as we said, it's a very welcome thing, but a very small thing.
Yes.
Treats appointments and transfers equally. as far as putting on the website is concerned. So reasons now have to be put up, is what the resolution of the Supreme Court itself says.
Yes.
We have to see to what extent they disclose the reasons. I've always believed that just telling you the conclusion is not giving you the reason. So they must do that. Secondly, I think you need to systematize it. You see, it is, nobody is saying that transfer by itself per se is bad.
Okay.
I've already given you the aberrations and the examples. I've even taken names. He has taken another name. But let me add that the real heartburn and anger is created when you apply the thing that you show me the name, show me the face, and I'll tell you the rule.
Yes.
That is the problem. It is as bad to transfer the three of us with or without reasons,
Yes.
as not to transfer you
Okay.
when you are in the batch of 4. So these things are what you see, whether you call it arbitrariness, ad hocism, discrimination, you keep thinking, you say, look, this judge in some other high court has been 10 years wanting to be transferred, not been transferred. Others have been transferred. So this has to be ironed out.
It's a very pertinent point. Mr. Khaitan, extending the discussion, what would be your view on this?
Look, number one, we are talking of a judiciary, an independent judiciary,
Yes.
which is the bedrock of our fundamental rights, and that's why we have the liberty. So what you're talking of is tinkering with a liberty. It is not just a transfer of some officer here and there. To what extent you can tinker with our liberty just because you want your own man or you do not want your own man? So I think the time has come when the public must know.
Public must know.
In my view, the public must know. Why? Because it affects your day-to-day liberty.
Justice Chamaleshwar also has made one more point, that the transfer of a judge, is not a resolution for improving a bad judge. If he is bad, you don't transfer him, because if he is bad in one high court, then he is bad in another high court too. There are several ways of disciplining a judge without transferring him, and he's also spoken on many other points and how this can be done. We'll discuss this further. But sir, when you hear this comment by Justice Chamaleshwar, what would be your reaction?
I think he is one judge who has come out openly
Yes.
for the good of the system.
Yes.
And I'll be absolutely one with him. But I doubt if in near future you will see a lot of improvement. No, I'm pessimistic on that, for reasons which I'll not delineate. I have grave doubts.
That
It will be a wonderful day if we improve the system, but I'm pessimistic about it.
You're pessimistic.
But it's wonderful that we have even a single voice coming out. It should not be allowed to die out.
Yes, it should not be allowed to die out. So Justice Jaspal Singh saying that Justice Chamaleshwar's voice is very important. Mr. Singhvi, your opinion on this
Yes,
issue?
we've already said that a lot of the things Justice Chalameshwar has been saying, and he has walked the talk. He has put his money where his mouth is. He has actually not attended collegium meetings without stating these very clearly.
Yes.
So today there has been a complete vindication and validation on both the fronts, appointments and transfers, as far as in principle is concerned. So I don't think anybody cannot but congratulate and commend his views. But the question you asked about the second part of what Justice Chalameshwar said, I think it's well-meaning, it's a point of view, but I respectfully don't agree with that view.
Okay.
The point you have made is that Justice Chalameshwar also said that if he's now here we are talking of actually bad persons who are sought to be transferred. You have to assume that I want to transfer you bona fide because there's a reason to transfer you, not that I'm doing it punitively. Now, if you take a bona fide reason, then I think transfer does make an improvement. I don't agree that a bad judge will remain a bad judge equally everywhere. The point is simple. In practice, the badness arises from the surrounding circumstances and the context. I am bad possibly because my relatives are practicing there, possibly because my links with the local bar is such, or there are other nefarious things going on. Obviously, the same conducive, harmonious surroundings for those malpractices do not exist in another high court. It is not the best solution, no doubt, but it is definitely an easier solution than impeachment. It definitely is a something which diminishes the evil.
And since you have taken up this
but that has to be done very carefully. Not that you transplant a sapling from something even more productive elsewhere.
Very quickly, Justice Chamaleshwar also suggested that there is a need to set up an appropriate legal regime to deal with situation where the conduct of a judge is required corrective measures other than impeachment. So would you agree that we need a...
Oh, absolutely. I mean, you see, if you notice the bill, NJC bill had a graded hierarchy of punishments, starting with the warning, censure, transfer, censor,
so this
transfer.
All you had all had figured
yes,
out?
Yes, even in the judicial standards bill,
yes.
I had the privilege of chairing the parliamentary committee which recommended that. We had a graded hierarchy because, as they say, the impeachment is the death penalty and nothing less.
Yes.
You can't straight away reach the death penalty.
Yes.
It's a very cumbersome process. I think there should be interim. There is no reason why over time, and you don't have a collegium like that yet, but eventually this may happen.
This has to happen.
Can say that, look, I only censor you, it's a mild thing. I give him more than a censor.
Yes.
Give me even more than that.
Yes.
And give him the worst. That can always
That's
happen.
a point. And Mr. Khaitan, your
a graded hierarchy is actually useful to calibrate your responses.
Yes, Mr. Khaitan.
Look, I think this grading is very helpful,
Yes.
and the judges in lower courts,
Yes.
they are being censored by the high courts in their supervisory jurisdiction, number one. Number two, I would think that all the judges' work should also become more transparent. How many cases he has heard, and the most thing is how many hearings does he require to do a simple thing, how many adjournments he is giving, and what is the time between the date of closing of arguments and the date when you give the judgment. Earlier, of course, now the situation is much better. Earlier we had cases where judges has heard the matter and he has retired without giving a judgment. Fortunately, those days are now less to be heard about. But if everything is put on the website and made transparent, then also I think a lot of improvement in the judiciary can be made. I would still say transparency is the first.
Transparency is the first thing. We'll take a short break, but after the break we are going to discuss that simply because a judge's son is practicing in a certain high court, should he be penalized by transferring simply for the reason that his son practices there? But this is after the break. Welcome back. So sometimes it so happens that it is presumed that a judge is transferred from a high court simply because his son practices in the same court. Isn't this unfair to a judge? Because though the common litigants don't know this, he won't be allowed to practice in the same court where his father is on the bench. So when this does not happen, why are judges supposedly being penalized for their sons being lawyers? Why a doctor's son becomes a doctor, or in other professions you see politicians' son becoming politicians. So why penalize and single out only judges, or why not? So I'll get Justice Jaspal Singh, and sir, how would you look at this?
I know of a judge whose son was practicing.
Yes.
And he used to file his wakalatnama in that very court.
Yes.
To get the cases transferred because some party wanted a transfer.
Yes.
There can be exploitation.
There can be.
There can be. There are 101 ways of exploiting it.
Yes.
There are cases where your brother judges will help the son.
Yes.
So that his son is helped by them.
Yes.
But that itself is no ground to transfer the judge.
There is no ground.
Because a little warning by the bar itself even.
By the bar itself.
Itself will be enough. Or by the Chief Justice or by some other system. This can be done. But you can't stop misuse of that. That's one thing. But positively, if it is happening, well, there are ways of stopping it.
Yes.
Not the way to transfer that your son is here.
That's a very important point. Judges shouldn't be penalized if their son is practicing in the same court. And I have some reasons to discuss here. I mean, you can have laws wherein the son shouldn't be allowed to use the official accommodation as office, or should say stay separately. That can be figured out. And I'd like to get Mr. Singhvi on this issue. Sir, how would you look at this issue?
I believe that India sometimes does more of paying lip service than substantive reform.
Yes.
We like to make a lot of rules which pay lip service. So cosmetically, everything is safeguarded. In substance, you can eat up the elephant also. We need to reverse that. I will tell you my answer in a minute, but give you this interesting anecdote about Lord Oliver, who told me personally is well on the English bar. His son used to appear before him.
Son used to appear before the father?
Yes, this is in the, as late as the 80s. But not a person ever imagined raising a finger, because that is known as substantive independence. I know that anybody who appears before you, you know the character of the person, you know the nature of the person. You can put all the safeguards and still you will not be able to prevent somebody else from misusing it.
Yes.
So that's the first point. The second point is that you have a dilemma genuinely. You can't make a rule saying that everybody whose sibling or child practices in the same code, or for that matter reverse, where the father or the brother practices the same code, must be transferred. Nor can you have an absolute system saying that it is of no effect. I think the answer is simple. It must be a factor going into the transfer on the merits of the facts of the case.
Yes.
We understand, I understand that here is a person, and frankly, in this matter, the bar is the best judge of the judges.
Yes.
The bar knows within 6 months whether this judge is abusing it, whether this judge is not abusing it, or this judge is half abusing it. And I think where it is gross, yes, transfer must happen.
In another 10
where it is,
seconds.
and the grossness is on all the tactics which he has described, many more tactics.
Yes.
Where it is not gross or an aberration, as you say rightly, just make a telephone call and tell the judge.
Before I go to Mr. Khaitan, in another 10 seconds,
Yes.
the former Chief Justice of India, Justice J.S. Keher, said that the bar never stands up for the bench. So there.
Yes, I think, I actually think that he was attacked rather viciously by certain persons, but there was no evidence.
There was no
and therefore he has a justifiable sense of hurt.
Justifiable sense of hurt.
Some of us did stand up in the sense that we made statements to the press that without evidence this is not on.
Yes.
But yes, he has a justifiable sense of hurt that collectively the bar kind of done. You should be careful in making allegations with some solid material. This is a very serious thing. At the end of a career, a man's career gets completely, his whole mental state. So I think that's a fair point to make.
That's a fair point to make. Mr. Khaitan, your opinion on this issue?
Well, you see, it all depends from individual to individual. Earlier, there was no bar of a relative practicing. I think Ashok Sen appeared before his father-in-law in Calcutta High Court. Of course, he was a brilliant lawyer. And there have been many such cases, as you said, even in UK. So it all depends upon that person. A person may be, a very sound character like Bhagwan Ram or somebody, and we have those people.
That era is gone. Now we don't have that era. Will not work.
So now the point is that, okay, if you want to now the important thing is, this is administration of justice. So justice not only has to be done, but to be seen to be done. So then in bar everybody knows what is happening. Let's be very clear.
The bar knows what's
happening. Knows exactly, and the judges also know. So if you have a collegium full court who can calibrate and give marks, as you were saying, then even these marks can be given whether he should be transferred on this ground or not.
Okay.
In a nutshell, each one of us in the bar knows the gross cases. Let me be very clear.
So
and you have to take action there, and on that excuse, you don't have to take action against him merely because he has a sibling practicing there.
Okay.
So you have to make that distinction.
Okay. And before we move on to what you can say, drawing this discussion to a close, I'll try to read out a small paragraph. The transfer provisions were meant for transfer by consent where exigencies required. In the Union of India versus Sakal Chand case of 1977, the actual transfer was withdrawn. But Justice Y.V. Chandrachud did not accept the consent principle. Justice P.N. Bhagwati, however, said that to transfer without consent was inimical to the independence of the judiciary. This, of course, has been written by Advocate Dhawan, and I would like to draw this discussion to a close by reading out this paragraph, and I would like to thank Mr. Singhvi, Mr. Khaitan and Justice Jaspal Singh. Thank you so much for sparing time and joining on this episode of Legally Speaking, and we'll track this issue in times to come of the transfers and how it evolves in the next 6 to 8 months, what deliberations are held. But that's it for now. Thank you so much for joining me on this episode of Legally Speaking.